All right, all right. I believe we are live. Let me know if you guys can hear me on the live stream. I am still working with this new mic. So let me know in the chat section if you can hear me. If you are new to my channel, my name is Boss Attorney Bree, and I am a licensed attorney in California. I practice trademark law, contract law, copyright law, business law, family law. So those are mainly the topics that I cover on this channel. However, we cover really popular cases or brands so that you guys can kind of know who we were talking about. So if you're watching this on a live stream, let me know where you're watching from. I am going to disconnect my earphones here because they are echoing all in my ears, so we're not using those today. Let me know if you guys can still hear me. I'm going to check my mic real quick to make sure that everything is still going pretty good. Just give me 1 second to get my life together here. All right, it says the mic is still working, so we are still all in the clear. All right, so today we are going to be talking about another trademark infringement slash counterfeiting lawsuit. If you were here last week, then you know we covered a trademark counterfeiting slash infringement lawsuit, and it was with Fashion Nova. And if you were here last week, you know that Adidas sued Fashion Nova for trademark infringement of its Stan Smith shoe. Today, we are going to be talking about another brand that is considered a fast fashion brand, copying another more exclusive brand. And just to let you guys know, I'm not all too familiar with this brand that's suing this company, but apparently they've been around since 1980 and they have collaborated with big brands such as Nike. So it seems to be a big brand. They didn't really go into too much detail about who they were. And in their complaint, if you watch my videos, a lot of the time we go over the introduction and they give a brief introduction into who their company is, why they're so famous, and why it's so appalling that this other company is copying them. But in this lawsuit, you guys are going to see that they didn't necessarily do that this time. And honestly, I didn't have time to research this company before doing this live stream, but I did see that they collaborated with Nike when I was looking for pictures to put onto the thumbnail. So apparently it's a brand that's been around for a long time. Let me know if you guys have ever heard of them. I'm going to stop beating around the bush and go ahead and reveal who we're actually talking about. We are talking about the Shein lawsuit. If you don't know who Shein is, I do know a little bit about Shein. It is a fast fashion brand. And unlike Fashion Nova, and the reason why I keep bringing up Fashion Nova, for those of you that didn't watch the live stream last week, is because we talked about Fashion Nova last week. And we talked about how they were a fast fashion brand. And I'm sorry, y'all, I don't know what's going on with my phone here. Let's see if we can get this thing working correctly. And then, okay. Looks like we're back on track. So it's a fast fashion brand. And with Fashion Nova, this is what's different with this case. I haven't heard a lot about Shein actually copying the designs of other brands or smaller creators, while Fashion Nova has always had, or not always had, but they've had this reputation for copying other designers, especially small designers, especially small Black designers. And so that's one of the issues that people have with Fashion Nova. But on top of that, they also have a problem with the fact that they're fast fashion. Like I said, I don't really see too much of Shein actually copying small brands, and maybe I just haven't seen it on my timeline, and maybe they do. But today we are talking about how they're copying this bigger brand. So not as big of an issue to me as far as stealing someone's work, because the big brand is giant versus like stealing work from a smaller creator. But what people have a big problem with, and people are kind of doing anti-hauls or anti-Shein and Fashion Nova and other small, pretty little thing, anti-videos on these brands, is because they are fast fashion. which means that they're made with pretty cheap quality. And on top of that, they are made in poorer countries and they're paying them low fees. So people don't like the inhumanity of it. And then on top of it being cheap clothing, it doesn't last very long. So it ends up filling our landfills. So that's the issue people have with fast fashion. The issue that this company here, which I'm going to reveal now, is Stussy. Let me know if you guys have heard of this company before. I've never heard of them before this, but like I said, it looks like they've been around for a while, since 1980. And they've collaborated with Nike, so they must have some type of clout. They said they're an exclusive brand, but we'll get into that in just a moment. But they are suing Shein because they said that they are copying them, and we have the exhibits today. So we're going to actually look at what they're saying they're copying on. If you looked at the thumbnail and you were able to kind of look real into it, the shoe actually has similar writing on it as the logo that I attached into the thumbnail. So that's what they're complaining about, the fact that they're using their name and the fact that they're using their name to index the shoe. So they're basically saying this is a Stussy shoe. And on top of that, the fact that they're using the same type of writing to write, or like as their logo. So they use a graffiti style in their logo, and that's what Shein is actually using on their shoes and their clothing that they're creating to make people think that it is really made by Stussy. So we're going to go ahead and pop over to the complaint. And today's probably going to be pretty short just because the complaint is shorter than the ones that we've had in the past. So let's go ahead and pop on over to the complaint here. Made it nice and big so everyone can see. And as we can see, this was filed on March 10th, so 5 days ago. We're pretty early. And it was filed for Stussy Inc. is the plaintiff. And it is against Shein and the Shein distributor. Oops, I did not mean to do that. All right. Let's go back. Highlighting problems. Okay, Shein and Shein's distributors. All right, so if you guys are watching on the live stream, let me know where you're watching from. If you're watching on the replay, let me know where you are replaying from. So they are filing this lawsuit for trademark infringement in the Central District of California, the Southern Division. And we'll see in a minute that it's because Stussy is actually incorporated in California. So they're suing for trademark infringement and counterfeiting. They like using that name recently. They have false or misleading descriptions and reputations and dilution under the federal Lanham Act for trademark infringement, and then also infringement of California and common law trademark and trade name rights. So pretty much the same thing as the federal rights, but it's actually under California law and then under case law. And then injury to business reputation and dilution, and unfair competition and unfair practices under California law. So they have 5 causes of action that they are suing this brand from. And so I'm going to pop back over because I see I have a comment came up, and we have the beautiful Lie says, what's good, Boss Bree? Keep up the quality content coming. Yes, thank you. Thank you for joining the live stream. I hope you are interested in this topic because I'm really interested in this topic. But yes, thank you for the comment. Where are you watching from? And I'm gonna pop back over to the complaint to see if we get an answer there from the beautiful Lie. And here we are. All right, so this complaint was a little strange for me because they decided not to go ahead and include an introduction, which is really where people generally put in the good tea into the complaint. So this one is a little, maybe that's why it's so short, because they decided to skip that. But I'm wondering what their plan or their theory was with actually skipping the introduction. You would want to put an introduction in something like a complaint, but hey, maybe they have a plan and we'll figure it out once this lawsuit actually goes to trial in a few years, because it usually takes a few years for it to go to trial. But let's pop on back over to the complaint and see what's going on here. All right. And so we're going to do jurisdiction. They're basically filing it in the California Central District Court because it's a federal case. And they're saying that the defendant, Shein, put themselves into California by trying to sell products in California, and basically saying that a substantial amount of the events occurred in California. It is also very convenient for them to file in California due to the fact that Stussy is incorporated in California, in the southern area of California. So it's easy for them to really go to court to defend themselves, or to not prosecute, but to sue Shein in this case. All right. And so the party is the Stussy Corporation, and then also Shein, and then Shein's distribution company as well, because I'm not quite sure if Shein actually makes their products or if they allow other people to design them and then they put them out. Something kind of like what I think Fashion Nova does. And so we have the beautiful lie supported from ATL. Okay, welcome, welcome. Did you come over from lead attorney? I know he's going live a little later. So I try to get my live stream out the way before the big dog comes in. But yeah, so let's go ahead and pop back over to the allegation. So we know who's suing. Let's talk about what they're alleging. Like I said earlier, Stussy started in 1980. Stussy has been and now engaged in business of manufacturing, promoting, distributing, and selling its high-quality clothing. All of Stussy's products are manufactured pursuant its strict specification and quality control. And so the reason why they're bringing that up is because they want the court to know that they don't just put out cheap quality things like Shein does. Shein sells things that people charge $50 for, like a shirt or something of that nature, for $5. You can get things on Shein for $5 versus Stussy is letting the court know that their products are high quality and pretty much they're going to charge a pretty little dime for whatever they're selling. Stussy has long used, prior to the acts of defendants herein, the trademark Stussy, including without limitation in standard character marks and in a graffiti style. Basically, they are letting the court know that they use it in plain text, and they also use it in a logo style, which they have registered with the Federal Trademark Office. And it's a graffiti style, which is what you guys saw on the thumbnail. Collectively, Stussy's trademark, are hereinafter referred to as Stussy's marks, are widely recognized and understood for standing for Stussy's excellent reputation and products. Again, emphasizing that they have superior products than the ones that Shein is putting out. Stussy is the owner and without limitation of the marks, and they have these registrations, one that was registered on May 27th, 1986, and it's this, it's just the regular words there. So they registered theirs a long time ago. And then they also have this trademark here. It's hard to highlight, so I'm just going to circle it, which is the graffiti style, which is what you guys saw on the shoe. And we're going to pop over to that real quick. So this is the shoe that Shein is selling. And this is the trademark that they're saying they're copying from it. I should have put it on a little thing where they were both right next to each other. So this is the actual Stussy's logo that's registered with the trademark office. And then this is the logo that's put on the Shein shoe. Do you guys think that looks the same? And we'll come back to that a little later. All right. And so we have my father's son. I always felt iffy about Shein. Yeah, they are one of those fast fashion brands that just kind of tries to get money wherever they can. It's being said that they're pretty unethical with their working conditions and the amount that they're paying the people that's working for them. And the clothes are cheap. I've bought things from Shein before, and they are pretty cheap, and sometimes they don't even fit right. So it's very easy for people to throw them away and fill up a landfill. So I understand why you've been iffy about Shein. And then we have Do What Thou Wilt. Welcome to the live stream. Thank you for joining again. And you say very similar. I agree with you there. I think the only thing that was missing is the 2 dots that they have. So the Shein, or not Shein, Stussy has these 2 dots at the top here. Let me get a different color to show you guys. They have this 2 dots at the top here, but the one that Shein uses, it didn't have the dots. And I think that's the main difference on it, but no one's looking that, I mean, people might look that close, but who's really looking that close on a shoe, right? So they have this graffiti style trademark. That's the one they're referring to as graffiti style, which they got registered with the USPTO, which is the United States Patent and Trademark Office, back on May 13th of 1997. So they've had this registration for 24 years, and then the other one for 25 years. And so they have the registration for clothing, namely pants, shirts, shorts, bathing suits, t-shirts, sweatsuits, and vests. And again, with the graffiti style, they have it for t-shirts, sweatshirts, jerseys, shorts, sweatpants, jackets, hats, caps, swimsuits, skirts, dresses, shirts, tank tops, pants, coats, and belts. And so you might be saying, okay, well, they don't have it for shoes, and Shein is actually creating a shoe. However, they are filed within the clothing class, and with the clothing class, it does include shoes. They don't necessarily have a trademark for shoes, but the fact that they're putting it on shoes, I've seen them collaborate with Nike when I was researching for this video. They'll probably have common law rights in the right to use this logo and the plain text words on shoes under the common law, and also under California law, because they do have it registered for shoes with the California Trademark Office, and they can still be protected under federal law because it will be considered a similar good. So even though they didn't necessarily name it in their application, they can fight that they have protection over shoes under the federal law, because shoes are a related good to clothing, hence why they're in the same class. And some people that make shirts also make shoes. So even though they didn't name it here, which is probably because they did their registration back in 1986 and in 1997, that's probably why they didn't name the shoes there. And so I misspoke earlier. I said they had the plain text one for 25 years. They've actually had it for 35 years. So they pretty much, they have a good amount of time that they've been using their trademark, honestly. So I think that they should have a pretty good case going forward. I don't think they alleged a lot in this lawsuit, so that may be where they're going to get in trouble by establishing that it's a famous mark. But it has definitely acquired distinctiveness. They've been using it since 1980. Okay, and so they have it registered with California in plain words, Stussy, and it's for clothing, and it includes the shoes and the sandals. They have another one registered in the California Trademark Office for Stussy Design. So remember, these are not the federal registrations. These are just for the state of California. And then they also have it in the stylized script, which is that kind of graffiti text for Stussy, and it includes the shoes and the sandals along with like pants, shirts, jackets, all of those things. And they're letting the court know that they have given notice that they actually use this trademark by putting the registered R on their product. So that gives people notice that it is actually a owned trademark. So you should not be using it. The good thing about federally registering your trademark is that the fact that it's on the USPTO's website, that serves as notice that someone is using this name as a trademark. And in order to prove trademark infringement, you have to prove that the person had notice. So the fact that they actually have registered trademarks will show that they had notice, and the fact that they put the registered R on their products will also help show that Shein had noticed that this was a registered trademark. All right. And then so we have, going back to the complaint, let me know if you guys have any questions. If you're not already subscribed, subscribe if you like this kind of content, and like the video if you are enjoying what is being talked about so far, or just to help out in the algorithm. Even if you don't like it, go ahead and like the video. All right, so back over to the complaint. Their registrations are valid, which they provide in an exhibit for. At all times, Stussy marks have been continuously in use by Stussy throughout the world and the United States, including California, in connection with manufacturing, distribution, sale, and promotion of the Stussy products. They don't have registrations for all of that, but they do have it for clothing, so that's good enough. As a result, Stussy's widespread and continuous use in advertisement and promotion of its products in connection with Stussy marks have become widely known and recognized as identifying Stussy as a source of a wide variety of clothing and related goods. So, like I said earlier, even though they didn't name the shoes are considered a related good under the federal trademark protection. They distinguish themselves from others. The Stussy marks have come to represent and symbolize the excellent reputation of Stussy's products and Stussy's valuable goodwill. Again, that's one purpose of trademark infringement. You have spent all of this money to build up this goodwill so that people will buy specifically from you. They want to protect it with trademarks in their trade. That's why they're filing a trademark infringement and counterfeiting lawsuit. And they also want the court to know that it has acquired secondary meaning. If you were on the stream last week, secondary meaning just means that people recognize that word as belonging to you. And it usually applies with things that are more on the descriptive side, or maybe it's like a last name or something. And it's generally said that you have acquired distinctiveness once you have been using the mark for more than 5 years. And as we can see in this case, they've been using the mark for 35 years. So they have acquired distinctiveness, and they said that they've done that throughout the United States, which is almost pretty easy to do nowadays because most people are selling things on websites. So let's go ahead and pop back to the complaint. I need to set up a button to where I can pop front and back instead of clicking. The Stussy marks are more valuable than ordinary marks because Stussy's business model is to create an exclusive brand with limited distribution. As a result, there is much unmet demand for Stussy's products and for Stussy's products with Stussy's look. As alleged below, defendants attempts to fill the market for Stussy products by diverting customers to defendant's website containing infringing products. So they are wanting to emphasize that they do not produce many of the items that they sell. Something like, I think Supreme does this, Louis Vuitton probably does this, and they only make a certain amount of their product. Maybe Birkin bags, they might do this. I don't know, because I don't buy all that expensive stuff. But they make a certain amount of their product so that people feel like it's exclusive. So you have to get it right now or you're going to miss out. Stussy is saying that they do the same thing. Maybe they make 5 of the t-shirts in all different sizes. And so in general, let's say 20 people can get that specific t-shirt. And so they're saying that they do that. And the fact that Shein is making these knockoffs, they're reducing the exclusivity of owning the Stussy products, which will make the demand lower for Stussy, or they won't necessarily sell out on every launch that they have. If Stussy does not want that, they have built their business relying on selling out of these products and having that FOMO, is that what it's called? Fear of missing out. That's how they built their brand, and they wanted to stay like that. But if Shein is actually producing fakes, then no one's going to rush to buy it because Shein's going to produce some fakes for them later on in life. So why would I rush and buy the more expensive one? All right. So they get right into the causes of action. Like I said, they didn't really allege much in this complaint. And so they're talking about the infringement and counterfeiting of federally registered trademarks. As I showed you earlier, they have a registration. Let's look at their registrations of their trademark. So they have this one, of course, in plain text, registered with the federal government. And then they have this graffiti style one, which is present on the shoes of, of Shein shoes. And then they have these California registrations. Where's the name on here? For one for Stussy. And these are just the trademarks that we listed out earlier. So it's for Stussy. That's their proof there. They have another one for Stussy Designs, as stated earlier. And then they have this one for Stussy in a stylized script. Let's see what that one looks like. I guess it's this instead of the one we saw with the federal. So they have 5 trademarks registered, 3 with California and then 2 with the federal government. So this one is talking about the infringement of the federal government registrations. So they said, with actual and constructive notice of the foregoing federal and state trademark registrations of Stussy's extensive and continuous use of the Stussy marks, defendants used and infringed on the marks by offering for sale, selling, and distributing products that bear copies and close reproductions of the Stussy marks. Defendants' use of Stussy is a counterfeit, and the mark is virtually identical to the genuine Stussy marks. Examples of defendants' counterfeit products are attached in Exhibit B. So let's look at Exhibit B, which are the trademark infringement. So let me zoom this back in. They made the picture so big when they filed this. So, why is it going all the way over there? Oh, because it's making that other picture ginormous. All right. So this is one of the shirts. So they're also using it in plain text, even though on the thumbnail, I used the graffiti one. This is the one in plain text, Stussy. They're outright using the trademark, the name right there. And it's on a shirt, which is one of the things they have a federal trademark for. And they call it Stussy's, the print is pretty small, Stussy something loose t-shirt. Okay. And then they have that, and let me zoom it back down to show the shoe. This is the thing that's on the thumbnail. So this is the shoe that they're saying is copied, and so that one uses the graffiti style. And I think some people earlier said it looks pretty similar. So let's pop back over to the actual trademark and let's see if it is similar. Which is that? Like I said, I feel like the only difference I really see, and I'm not a handwriting expert, so maybe that's why it's the only difference I really see, but you can see it looks pretty similar. If you're just glancing at it, it will be very hard to be like, oh no, that's not a real Stussy. And then the one that's registered, I guess there's a little bit of space in there. Right here, they have a little bit of space right here to kind of show that it's a knockoff, but for the most part, it looks pretty similar. All right. They're claiming that they knew that the acts were infringing and they indexed the products under Stussy products. And they also have a review saying the shirt looks like a real one, basically saying that it looks like a real Stussy shirt. So that's not a good look for them. I didn't see that they included that comment on this lawsuit, like in the exhibits, but they can produce it later, of course. So hopefully Shein doesn't go and delete it, right? All right. So defendant, which is Shein, has done this without Stussy's consent, used it in commerce, reproductions, infringement, copies, and colorful imitations of the Stussy's marks in connection with the sale, offering for sale, and distribution of goods and services on or in connection with such use, which caused confusion, mistake, deception, violating the Lanham Act. So the Trademark Statutes. Defendants' knowledge of the acts are wrongful, and they have committed acts that they alleged above with the sale and the offer of the sale of the goods and services. They also infringe by promoting the sale, offering to sell, distributing the goods, and deceive purchasers, and will in fact continue to cause confusion and mistake and deception with the purchasers, which is their whole point. That's why they're copying them, because they know people are going to buy it, especially if they're selling it at a way lower price point. So we have them. I don't know how much they're selling the shoes for, but let's see how much the shoe costs. Oh, this is the wrong one. All right. Let's see how much they have the price for the shirt. So I have to zoom it in. Okay. Boom. I think it was like $17.99. It's about, let's say $18. Let's look up Stussy. Oh, they have a website. Okay. Well, they all say sold out. Well, that's what they mean, though, right? They said that they only make a certain amount so that people will buy them fast. And so that's what they did here. All right. I don't see a similar shirt to the one that they have, but their shirt is $65. I saw another one. I'm looking at the long sleeve ones because that one's long sleeve. $80, $130, but that one's more of a jacket. Let's see. Long sleeve shirt, $85. And they're selling theirs for $20. And those are men's shirts. Shop tees. All right, we'll go with tees. $40 for a regular t-shirt. So still underpriced, like half off. This one is probably a little bit more similar to what they have, even though it's not a hoodie. It is $115. Or was theirs? Oh, theirs was a short sleeve too. Okay. So $40, about half price, a little under half the price that they're selling it for. Which will dilute or make people not want to buy the real ones because it's more expensive to buy the real ones. Why would you buy the real ones when you can just buy a fake one for $20? All right. So defendant's promotion, sale, offering for sale, and distribution of its products by means of infringing use of the Stussy marks has caused a lot of sales of Stussy's genuine products and will result in the loss of future sales to customers unless enjoined. Again, because they can just go and get a fake one from Shein. Why would they participate? Why would they participate in the launches that Stussy is having for a $40 shirt when they can just go on Shein and get it for $20 or get a different style of it for $20? Unless restrained by the court, they're basically saying that they're going to suffer irreparable harm if the court does not stop them. They want for Stussy has suffered a loss of profits and other damages, and defendant has earned illegal profits in the amount to be proven at trial as a result of defendant's or aforesaid acts. Such damages and profits should be trebled in accordance with the Lanham Act. This constitute intentional infringement. And why they want to say that it's intentional infringement is because if you can prove that it is intentional, willful infringement, then you can get more money. You can get punitive damages. You can get attorney's fees. If you only prove that you infringed, then you're looking more at just actual damages. How much profit did Shein obtain by using your trademark? But if you show intentional, then you get more money. And if you watch the Tasha K lawsuit, you saw that getting those punitive damages and the attorney's fees boosted the award amount to Cardi B by $2 million. So yes, you want to show that you deserve attorney's fees and punitive damages to stop other people from trademark infringement like this, especially these fast fashion brands, because they have a large customer base. And they can sell all of these cheap things and make a lot of money versus Stussy, who has these exclusive launches and probably an exclusive target customer base. And sometimes people don't got $40 for a t-shirt, but they have 20, so they might go to Shein instead. So this is why they want the punitive damages and the attorney's fees in order to get more money. Because it does cost a lot of money to sue someone as well. So even if they don't get the punitive damages, I'm sure they would like the attorney's fees because it kind of reimburses them from having to sue these people. But for Shein copying them, they would not have had to file this lawsuit. So I think it's reasonable to try to get attorney's fees. What do you guys think? Do you think they should want attorney's fees, or do you think that they should bear the own cost of them suing Shein, this fast fashion brand? All right, so defendants' products and images of such products being promoted, or this one, sorry, is for false and misleading descriptions and representations and dilutions. And most of this stuff is kind of going to be re-alleging everything else that was kind of already said above, because a lot of these causes of actions require the same facts to be pled. So they're just saying that defendants' products and images of such products being promoted on the Shein website constitute the use of words, terms, names, symbols, basically saying that they're using the actual trademark, and it is causing false designation of origin, false and misleading descriptions and representations, and have caused or likely to cause confusion, mistake, and deception as to the affiliation, connection, and association with defendant and or with Stussy, and as to the origin, sponsorship, and approval of the Stussy goods and services. So they're saying the fact that they're using the Stussy trademark may confuse people and make them think that Stussy is actually collaborating with them. Because if you remember from earlier, I said that Stussy has actually collaborated with Nike. So Stussy may have become known to collaborate with other brands, and people might think that they decided to collaborate with Shein. I don't know why they would do that and sell their products for less money. You would want to work with a brand that's more on the same price tag as you, right? So people might think that they decided to collaborate with Stussy. They should have put those facts in here. Stussy works with other brands, and people might think this is a collaboration when it's not. They probably should have alleged that as well. I don't know why they didn't include that. All right, so likely to cause confusion, misrepresentation, that they make these false representations regarding Stussy's goods and services. Such representations are made and will be made in connection with commerce. So they're making it in connection with the sale of the products. Stussy does not consent to the use of their name, and then they go on to allege similar things that is going to cause confusion to the public. It has an infringing websites and advertisement, and it's going to decrease Stussy's valuable goodwill and business representation because, like we said earlier, Shein makes really cheap products. And so it makes sense why Stussy, if they are charging $50 for a t-shirt, does not want to be associated with these cheap products that Shein be putting out. Okay. And so now we are on to the third cause of action, which is just the California Commonwealth trademarks and trade name infringement. And again, alleging pretty much the same thing. Defendant has acted with oppression, fraud, and malice, and that defendant's conduct was intended by defendant to cause injury to Stussy, is despicable and was carried on with a willful and conscious disregard for the rights of Stussy and the public. Again, alleging intentional infringement so that they can get more money from bringing this lawsuit. Lawsuits are really expensive to have. So, like I said earlier, it makes sense that they would want their money back for having to go through the trouble to sue them. Even though Stussy probably has in-house counsel or they had to hire someone, either way, it's expensive. All right. So again, lost profits, all that good stuff. They are saying injury to the business reputation and dilution, basically saying the use of the name is going to decline the value of the Stussy mark. Shein's use of colorful copies and imitations of the Stussy marks are likely to cause injury to Stussy's business reputation and to dilute distinctive quality of Stussy marks in violation of California trademark law. They have acted, and if they continue to be able to act, they are going to cause more damages to Stussy. So they're asking the court to make them stop using it. And again, unfair and fraudulent business practices by the acts that they have already alleged. It has impaired Stussy's valuable goodwill and has created the likelihood of confusion and have actually confused the public, as indicated by that comment that, hey, it actually looks like a real one. That's not good. You don't want someone to say that on your website because that's basically your customers admitting to your infringement. So you don't want that happening on your website. So boom. I'm trying to see, how do I make my name go away? I'm gonna have to figure that out at a different time. All right, so we're going to move right on into the prayer of relief. I don't see any questions coming in. Let me know if you guys have any questions on the trademark lawsuit. And if you just have questions on trademark in general or business in general, let me know, or questions for me in general. Let's pop back over to the complaint and see what's going on. And we're now in the prayer for relief, which is basically asking the court to award certain things to the plaintiffs, which is Stussy's Incorporated. And so they're basically asking the court to stop anyone related to Shein, agents, servants, employees, attorneys, successors, anybody related to Stussy, to Shein, from doing these following things: infringing on the Stussy's mark or using or causing the use of any of the words, terms, names, symbol, devices, or combination thereof that causes or is likely to cause confusion, mistake, or deception. They also want the court to stop them from using or causing the use of the words, again, that will create confusion, mistake, or deception as to the affiliation, origin, or association to the Stussy mark, or to Shein, from Shein to Stussy. So basically wants them to stop using the name again, stop diluting and infringing on the rights of Stussy, stop making false and misleading statements as alleged above, and otherwise competing unfairly with Stussy in any manner. Basically, just stop using their name. They don't want to have to fight with you. They don't want to have to keep suing you, as we see Fashion Nova just keeps getting sued by Adidas over and over. So Stussy is basically trying to say, don't make us have to sue you over and over like Adidas is suing Fashion Nova over and over for copying them. They said within 30 days for Shein to stop the infringement, so to stop selling the Stussy products. They gave them 30 days, which is good for them to get rid of their inventory. But after that, they have to stop selling it. A defendant within 30 days after service of the judgment be required to file with the court and serve upon Stussy's attorney a written report under oath, setting forth in detail the manner in which defendants have complied with the judgment. Basically, how did they stop using the mark? Did they take everything off the website? Are they still infringing on Stussy's right? They would like to recover the lost profits and actual damages of they would like to recover the lost profits and actual damages from the defendants and the amount to be proven by trial, but it has to be over $75,000 in order to be in federal court. So they are saying that it will be over 75,000. And then I have a comment coming in, and I'm not quite sure what that means. Ver FYI. I feel like I've seen that before, but I don't know what ver means. So can you please let me know what that means so I will know next time I see it? Because that's not the first time that I've seen that before. All right. But I have no idea what that means. All right. And then they want to recover attorney's fees, as we talked about earlier. Any taxable costs and disbursements. So when they pay them, they also want them to pay the taxes. That's a good one. I haven't seen that one in a while. And then the court grants us such other relief. So basically a catch-all phrase. If we missed anything, also grant us that as well. And so before we log off for the day, I am going to pop on back over to the infringing products and the trademarks to see whether you guys think that it is confusingly similar or if you think they're completely different. So these are the things that Stussy submitted to the court saying that Shein is copying them. So this is a Stussy shirt that Shein has on their website. They labeled it under Stussy. Do they label it under anything else they can click on? Not up there, but it's sold out, just like the Stussy products on their own website sold out. Well, these ones aren't sold out, but the other page I was on was sold out. All right, and then we go. Oh, they did use the some of the comments. It says cute, but lettering is bad, but they gave it 5 stars. And then such a special, simple, and nice Stussy printed t-shirt that I like. I would definitely wear it every single day. I love it. So they think that it's really a Stussy shirt. And then, oh, I gotta zoom back out. I don't know why they put the pictures on here so ginormous. I have to zoom all the way back out. And then these are the shoes. And remember that little graffiti style, because I'm gonna switch over to the actual trademarks that Stussy has. Fashion Sport at Web something. I think they use like some stuff like this at the bottom as well on theirs. And boom, looks like they went ahead and bought them some shoes so that they can sue them. Or someone bought the shoes and sent it to Stussy. All right. And then so this is the graffiti trademark that Stussy has. I think the difference is those 2 dots. And I might be completely saying their name wrong, because I think those 2 dots, you're supposed to pronounce it a certain way, but I don't know. I don't know how to do it, and I didn't look up how to do it, so that's my fault. And then they have that. I see a space right here. I see the S, the T, the similar styled U, and then I see an S. And then is that also another S, or is that part of the Y? That's Shein's product. And then let's go over here. Oh, I think it's part of the second S. We have a S, T, 2 dots, a U, and then the S, and then a S, and then a Y. So they shaped it a little bit different, I think. I wish I could make it pop up all at once. Can I do that? I don't think I can share 2 screens at one time. I'll have to figure that out. But yeah, I think the U, S. Oh, there's the second S. Okay. It's at an angle, and the Y. Yeah, so yeah, the Y is shaped pretty similar to the one that they have. Yeah, I think it's pretty similar. Let me know what you guys think, if you think it's similar. And that, I think that was all. And then, yeah, they just have regular trademarks, and then they also put it on their shirt like such. Let's see what their shoes look like. Let's see if they have anything similar there. I'm not seeing shoes. Can I search this? All they have are these on the website, which are $35. And then I saw that they had some. Let's go to Google. And let's go to Stussy Shoes. And let's go to images. I don't really see any shoes that they have that's the same as the ones that it looks like they just like collaborated with Nike. But I'm not seeing anything that looks similar to what the Shein had. But that doesn't matter. They use the actual name. So they're not claiming trade dress infringement, which is what Adidas was actually claiming on that Fashion Nova lawsuit that we went over last week. They're only claiming trademark infringement. So just the use of the name and the logo is enough for that trademark infringement. So they didn't necessarily copy the shoe and copy the trade dress like Adidas is alleging against Fashion Nova with the stance trademark infringement, because this looks like this and people will confuse those things. So let me know what you guys think about that. If you think that this is similar to this. And then this one is just an outright using the name. So yes, trademark infringement on that end. And then the logo, I think it looks pretty similar. I don't think that they made it different enough. Like I said, they have this, let me get a highlighter here. All right. They have like this space right here, but the actual trademark doesn't have this space right here. So that's the most difference that I can see. And then the 2 dots at the top. But let me know if you guys saw any other difference in the name. All right. So that was it for the complaint. If you guys missed it, be sure to watch it on the replay. So this will be up after I'm done with the live, going over everything that was in the complaint. Let me know what you guys think on the case. Comment it in the chat box. And if you watch it on the replay, comment it in the comment box to see if you think that it is the same. I think that they could have alleged a lot more in the lawsuit. And the thing about complaints is you don't have to allege everything that you have. You just have to allege facts sufficient enough to show that you have a case. And they decided to go with very little facts in this case. I think it was their facts page was probably like a page or two long, which is not very much information. And they did not provide an introduction, which I thought was pretty weird. So yeah, their allegations is about 2.5 pages, and part of the allegations includes the actual trademark registrations and what they're registered for. So they definitely did not include a lot in their allegations, which could potentially hurt them in the future, but maybe it won't. We'll see what Shein says and how they respond to this lawsuit. All of these little fast fashion brands are kind of getting sued now. Not all of them are getting sued, but there are several of them being sued. Like I said earlier, we talked about Fashion Nova case last week being sued by Adidas. Now we have Shein being sued by who is it? Stussy. And there are a couple of other things going on in the world too. I saw a case that some restaurants are suing Google, so I might talk about that on Thursday. But I don't really know if I want to go through that complaint. So we'll see if we'll talk about that. There's Hershey's is suing a small ice cream company or something like that. So everyone is suing everybody for trademark infringement, which lets you know that having your trademark is pretty important, especially if you plan on being a big brand, because you don't want anyone ruining your reputation or stealing sales from you. So if you guys have businesses, or if you run a YouTube channel and you want to make sure no one can steal your YouTube channel name or your business name, then you definitely want to look into getting trademarks. Make sure to comment below what cases you might want to hear, or if you've seen something in the news that you think I should cover, let me know. But I am going to hop off the live stream today, and I will catch you guys on Thursday. Thank you for joining.